Let's take a look at harassment from an employment law perspective. Harassment is a major obstacle to realizing equal employment opportunity. Harassment can intimidate and isolate employees, keep them from doing their best work, result in physical and psychological harm, and ultimately drive its victims from the workplace. Employers are clearly on notice that harassment will no longer be tolerated. Eliminating harassment is among the most pressing legal concerns facing employers today. Although sexual harassment claims are the most common type, and most of the law centers on sexual harassment, harassment also affects other protected classes. Racial harassment is a long-standing and still prevalent problem. Employees also experience and seek legal protection from harassment based on their national origin, age, disabilities, and religious beliefs. Harassment is manifested in different ways, but the fundamental nature of harassment and employer liability for it is the same regardless of the protected class involved. Harassment claims are brought under general anti-discrimination laws, such as Title VII of the Civil Rights Act, rather than under laws specifically addressing harassment. In sexual harassment cases, the plaintiff must show that he or she was subjected to harassment because of his or her sex. Both men and women are protected from harassment. In recent years, roughly 17% of sexual harassment charges filed with the Equal Employment Opportunity Commission have been brought by males. Regardless of their sex, to be successful in making a harassment claim, plaintiffs must show that they were exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. In other words, someone of the opposite sex would not have been subjected to harassment, or any such harassment would have differed markedly in nature. Establishing the discriminatory motivation behind harassment can be difficult. Consider same-sex harassment cases in which the harasser and the person harassed are of the same sex. Although sexual attraction is not the only reason that employees are singled out for harassment, judges often have difficulty concluding that heterosexual harassers choose to harass people of the same sex because of their sex. The three methods offered by the Supreme Court for establishing that same-sex harassment is discriminatory are not exhaustive. Some courts have also used the theory that sex stereotyping to find evidence of discriminatory motive in same-sex harassment cases could be used. In cases where both men and women are victimized, courts often conclude that harassment does not disadvantage members of one sex relative to the other, so it's not discriminatory treatment based on sex. Questions about whether harassment was because of sex also arise when there's evidence that the harasser's personal hostility towards the plaintiff exists. Harassment, such as continuous sexual banter or graffiti that's not directed at anyone in particular and to which both male and female employees are subjective, can also present problems for plaintiffs. Current legal protections against harassment do not cover the full range of bullying and abuse that occurs in the workplace. It is clear that not all harassment can be linked to protected class in the manner required to prove discrimination. We need to step back and consider more carefully the kinds of behaviors that constitute harassment. The EEOC has defined sexual harassment as follows: unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when one of the following conditions is present. Submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting such individual. Such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. A distinction can be drawn between harassment that results in tangible employment actions and harassment that alters working conditions by subjecting employees to hostile environments but does not affect tangible employment outcomes. This distinction is important because the criteria for finding employers liable differ depending on which of these two types of harassment has occurred. Harassment sometimes results in significant changes in the employment status of individuals. In the classic example, a manager tells an employee that he wants to receive sexual favors from her and that she must comply or her career will suffer. The employee resists this sexual advance and is demoted or fired shortly thereafter. The employee's response to harassment has had a tangible effect on her employment opportunities, and she would have a strong harassment claim. Harassment that results in tangible employment action often involves a sexual advance that can be traded for some employment outcome. The Latin term quid pro quo, what for what, or this for that, is often used to describe these cases. Some courts have also held that the prohibited quid pro quo also occurs when employees submit to unwelcome advances to obtain employment opportunities, like to get a raise, or to maintain existing opportunities, such as to keep one's job. In a tangible employment claim, the harasser must possess significant authority to influence or determine employment outcomes, or at least be reasonably perceived as having such authority. However, if a supervisor threatens an employment consequence but does not take any action when the employee refuses his or her sexual advance, there's no tangible employment action, although there might still be a hostile work environment. For a tangible employment action claim to succeed, it's critical that the plaintiff show that the tangible employment action is causally linked to the rejection of or submission to harassment. Courts do not require evidence that the harasser explicitly linked harassment in a subsequent employment decision, but the mere fact that a tangible employment action coincides in time with the occurrence of an advance is not enough. What about an employee who is subjected to severe harassment and quits to escape the situation? A resignation under these circumstances is termed a constructive discharge and is treated by the courts as a termination. If an employee is forced to quit because of harassment, that loss of employment is clearly tangible in terms of having a significant effect on employment status. Yet quitting a job is not the same as a termination in the sense of being an official act that might prompt managerial review. The Supreme Court has determined that a constructive discharge will be deemed as a tangible employment action only if an official act such as a demotion or pay cut prompts the quit. The logic of this decision is closely tied to the rationale for distinguishing between tangible employment action and other harassment cases when attributing liability to employers. Most often, harassment does not directly alter employment status. Instead, it imposes inferior working conditions that make it harder for an employee to perform well or remain on the job. A hostile work environment can result from a wide range of verbal conduct, physical conduct, and displays of images. Examples of behaviors that may constitute a hostile work environment include insults, jokes, profanities, pictures, emails, pornography, requests for sexual favors, touching, exposure, staring, stalking, sexual assault, and rape. Hostile environments can be created not just by managers and supervisors, but also by coworkers and third parties like customers and clients. Although sexual harassment claims frequently entail words, conduct, or images of a blatantly sexual nature, it's important to realize that sexual harassment can take other, non-explicit sexual forms. The key issue is whether an employee is subjected to unwelcome, offensive treatment because of his or her sex. There need not be sexual conduct involved. In one example, a sexual harassment claim was successful even though unrelated to sexual conduct, when the employee was able to show a hostile work environment. She had evidence that her supervisor frequently stood at her desk and stared angrily at her, startled her by pounding on her desk with his fist, criticized her work unfairly, and yelled at her in front of coworkers. Likewise, 2 years of making repeated comments about the type of underwear being worn by female employees, throwing her food away, and removing items from her desk were sufficient to state a claim of sexual harassment. The court observed that there is no legal requirement that hostile acts be overtly sex or gender specific in content, whether marked by language, by sex or gender stereotypes, or by sexual overtures. Similarly, although crude racial stereotypes are typical components of racial harassment claims, a builder subjected African American sales representatives to a racially hostile environment based on work assignment. Job assignments are not typically regarded as adverse employment actions that can be challenged in discrimination claims, but in this case, they were assigned based on their race to high crime areas without adequate security. The inferior working conditions were sufficiently severe or pervasive to constitute a hostile environment. The law does not mandate that employees be treated in ways that are nice or even civil. However, employees have the right to not be forced to endure hostile environments based on their protected class characteristics. But how hostile must the workplace become before the law is violated? The basic standard is that a hostile environment must be sufficiently severe or pervasive to be actionable. Severity gets at the degree of harm posed by particular acts, and pervasiveness addresses the frequency and regularity of harassment. Victims of harassment need not suffer psychological harm, although evidence of any such harm is relevant to a hostile environment claim. Conduct that is physically threatening or humiliating or that unreasonably interferes with an employee's performance reaches the threshold of a legally actionable hostile environment sooner than mere offensive utterances. Even so, there's no simple, bright-line test for distinguishing conduct that's merely offensive from a legally actionable hostile environment. A trade-off exists between severity and pervasiveness, such that conduct that is more severe need not happen often. Once is enough for a sexual assault. Less severe conduct, like insults, must occur more frequently or over a long period of time to constitute a hostile environment. Challenges to racially hostile environments are also quite common. Employers that do not respond to these offensive displays with the strongest disciplinary measures are not living up to their responsibilities. Individuals can view the same situations very differently. Verbal and physical conduct that would otherwise constitute egregious harassment might be entirely welcomed and engaged by two employees who are in a relationship or who are just friends that routinely tease each other. Although the principal focus in harassment cases is the objective existence of harassment viewed through the eyes of a reasonable person, plaintiffs also must show they subjectively perceived their treatment as unwelcome. Harassing conduct is unwelcome when the person complaining of the conduct did not solicit or provoke it, and that person regarded the conduct as offensive and unwanted at the time that it occurred. A circumstance that can cause the unwelcomeness of conduct to be questioned is when an employee fails to tell the harasser or the employer that the conduct is offensive or waits a long time before reporting it. Victims of harassment are not always required to confront their harassers. Sometimes they're well advised not to do so. Nor must they always report harassment to their employer to establish that the conduct is unwelcome. Some indication of unwelcomeness, even if nonverbal, however, is important to the plaintiff's case. Another problematic situation occurs when a prior romantic relationship goes sour, and a party that no longer desires to maintain the relationship continues to be pursued by the other party. It is particularly important in these cases that the person who no longer desires romantic attention clearly notify the person of this and act accordingly. Employers seeking to defend harassment claims also sometimes argue that any harassment was not unwelcome because the victim provoked or actively participated in the harassment. An employee's own salty language, flirting, pranks, and even sexually provocative appearance can provide indications that the individual was an active participant in, rather than a victim of, harassment. What about men who are harassed by women? It is often assumed that men, at least heterosexuals, are more likely to welcome such attention than women. An employee's voluntary or consensual participation in sexual activity is not necessarily fatal to the harassment claim. The core requirement of any sexual harassment claim is that the alleged sexual advances were unwelcome. Welcomeness and voluntariness are distinct matters. When someone whose position allows him or her to speak and act for the company engages in harassment, the company is liable for the harassment. This is true regardless of the type of harassment. Vicarious liability means that if the illegal acts, in this case harassment, occurred, legal responsibility for damages is unconditionally placed with the employing organization. The organization cannot avoid liability by showing that harassment was contrary to its policies or in spite of its best efforts for prevention. For managers and supervisors other than top officers, the liability story is a bit more complicated. Indeed, identifying who is a supervisor can be tricky, as job titles do not always capture the fine graduations of authority attached to positions, and there's no uniform legal definition of what constitutes supervisory status. For purposes of assigning liability to employers in harassment cases, supervisors are individuals who exercise immediately or successively higher level authority over victims of harassment. The nature that authority is such that they have the power to make significant change in employment status, such as hiring, firing, failing to promote, reassignment, with significantly different responsibilities, or a change in benefit. Vicarious liability is the norm in discrimination cases. If a manager discriminates older workers when deciding who to lay off, the company is liable for that discrimination, regardless of whether top managers were aware of the practice or encouraged it in any way. In harassment cases, the general rule of vicarious liability for discrimination is adhered to when the harassment results in a tangible employment action. If a manager or supervisor uses the decision-making authority that's been conferred to them to try to exact sexual favors and then makes employment decisions accordingly, the employer is vicariously liable. Even though the supervisor or manager is likely acting outside the scope of his employment in doing so, he is still an agent of the employer and aided in carrying out the harassment by being given authority to make employment decisions. Often, managers and supervisors engage in conduct that creates hostile environments for employees they manage but does not result in tangible employment action. In such cases, employers can avoid vicarious liability by establishing both prongs of the following affirmative defense. First, the employer exercised reasonable care to prevent and correct promptly any harassment. Second, the plaintiff unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or avoided harm otherwise. Whether reasonable care to prevent harassment was exercised depends first and foremost on the existence of a sound harassment policy and complaint procedure. Absent a legally adequate policy prohibiting harassment and identifying a set of actors to whom harassment complaints can be made, an employer will almost certainly be unable to establish an affirmative defense. Reasonable care must be taken not only to prevent harassment, but also to correct any harassment that nonetheless occurs. In general, employers need to show that they acted promptly in responding to employee complaints, conducted effective investigations, and took steps reasonably calculated to remedy harassment and prevent future incidents. To prevail using the affirmative defense, employers must not only take the necessary preventative and corrective measures, but also show that their employees unreasonably failed to take advantage of these measures. The most common, though not the only reason for finding that an employee has acted unreasonably is a delay in reporting harassment. Courts have clearly placed the burden on employees experiencing harassment to come forward quickly and to use their employer's established reporting mechanisms. Employers or third parties without authority to make employment decisions are effectively precluded from engaging in harassment that results in tangible employment action. However, coworkers and third parties are quite capable of creating hostile work environments for employees. Employer liability for hostile environment harassment by non-supervisory coworkers and third parties rests on whether the employer was negligent in not protecting the employee from harassment. Specifically, the employer is liable under the negligence standard for harassment by coworkers and third parties where the plaintiff can establish both of the following. First, the employer knew or should have known about the harassment, and the employer failed to take prompt and appropriate action to stop the harassment. Considerable overlap exists between this negligence standard and the affirmative defense, but here it is the plaintiff that must prove these criteria have been met. The first element establishes that the employer had actual or constructive knowledge of the harassment. That is, the employer knew of the harassment or should have known given its prevalence or visibility. A timely and specific complaint to the employer is the simplest way to establish employer knowledge, but employers cannot use the ostrich defense to ignore blatant harassment even in the absence of specific complaints. However, it is important that the actual or constructive knowledge of harassment rests with someone in a management position charged with at least the general responsibility for doing something about it. Once employers become aware of the harassment, they are responsible for taking actions reasonably calculated to stop it. The measures required depend on the seriousness of the harassment. However, the failure to completely prevent further harassment is not proof that the employer is negligent if prompt, reasonable action was taken. Employers have less control over third parties, but still must use available means to protect employees from harassment by clients, customers, and contractors. Employers should establish, communicate, and enforce policies prohibiting harassment. Although failure to adapt policy is not by itself a violation of the law, a policy is basic to preventing harassment. Employers will generally not be able to show that reasonable care to prevent harassment was exercised and establish the affirmative defense in the absence of a formal policy. Real policies have more than a paper existence. They must be communicated, reiterated, adhered to, and enforced. Harassment policies should be included in employee handbooks, made available in multiple languages when necessary, posted in visible areas, discussed when orienting new employees, and made the subject of training. The efficacy of training in the prevention of harassment is open to question. When performed appropriately, training can make employees more aware of the conduct expected of them and what to do if they're confronted with harassment. In recognition of limitations of conventional harassment training and of the wider problem of workplace bullying, there's an increasing interest in workplace civility training. Such training, which typically incorporates interpersonal, conflict resolution, and supervisory skills, has the virtue of focusing on what employees should do when interacting with one another rather than what they should not do. Employers should provide training regarding prevention of harassment and discrimination more generally. This training needs to be geared towards the particular employee audience and part of a larger set of preventative measures. An adequate policy must unequivocally inform all employees that harassment is prohibited by company policy and the law and will not be tolerated. Concrete examples of harassment can be helpful, provided it's made clear that no listing of harassing conduct is exhaustive. The policy should clearly state that it applies to electronic communications, including offensive content conveyed by email, text messages, or social media site posts. Employees should also be alerted that harassment, based on other protected class characteristics such as race and national origin, is prohibited by company policy and is illegal. Employees must be told how to report harassment and be provided multiple accessible parties. Under no circumstances should an employee be required to report harassment to a supervisor or manager who is the alleged harasser. Harassment policy should require that supervisors and managers with knowledge of harassment, however gained, report it to appropriate people designated to handle investigations. It is vital that harassment policies provide strong and credible assurances that people reporting harassment will be protected from retaliation. Employees subjected to harassment are often doubly victimized, first by the harassment and then by retaliation for complaining. A complaint process cannot be effective if employees have reason to fear its use. The employer's response to reports of harassment is critical. Employers must respond promptly and in a manner reasonably calculated to stop and correct any harassment. A complaint of harassment is not something to be placed on the back burner. Courts can be tough on employers that do not respond promptly to complaints of harassment. In one case, a woman being harassed by a coworker complained several times to the individual designated to receive complaints, only to have the complaints laughed off and to be told that the coworker is such a ladies' man. The manager who failed to act was terminated after a higher level manager became aware of the situation and steps were taken to end the harassment. However, the 4-month delay raised a question of material fact whether the defendant's response was sufficiently prompt. This promptness and adequacy of an employer's response are assessed in light of the seriousness of the alleged harassment. In a case involving harassment that resulted in criminal charges against the harasser, the court found the employer's response not to be sufficiently timely when the employer delayed the start of an investigation to later in the same day. Once informed of possible harassment, employers should look into the matter despite any hesitation that the employee has about going forward with a complaint. Although courts sometimes overlook employers' failure to act when employees insist that they will handle matters themselves, the better course of action is to commence an investigation. At that point, the employer has been made aware of possible harassment and has a legal responsibility to protect employees from that harassment. Employers should establish mechanisms for employees to receive information about harassment anonymously before deciding whether to make reports to their employers. Investigators need to remain neutral and resist any pressure from the parties to draw conclusions before all evidence is gathered. Discretion, but not absolute confidentiality, should be promised. An effective investigation necessarily means that others will become aware of the allegations. Further, employees generally enjoy the right under the National Labor Relations Act to discuss workplace issues and seek support in dealing with them. A rule prohibiting employees from discussing ongoing investigations of employee misconduct could break the law. But within the bounds imposed by the practical necessities of conducting investigations and by labor law, employers should endeavor to limit information about harassment complaints to those with a legitimate need to know. Allegations of harassment can be highly damaging. If they are false and indiscriminately published, the wrongly accused employee could have a defamation claim. Employers need to take harassment complaints seriously, but must balance this against respect for the rights of the accused. This is not always an easy balance to maintain. Some employers include specific warnings against false claims in their harassment policy. Although knowingly false allegations of harassment, to whatever extent they may occur, are clearly reprehensible, the most likely effect such policy language is to further chill the reporting of harassment. Thus, such statements are best omitted from harassment policy. Employers should take initial, temporary measures upon receiving harassment complaints and long-term remedial measures based on the outcomes of investigations. The initial measures are to separate the parties and prevent harassment, if any, from continuing. Transfers, shift changes, leaves of absence, and closer supervision of the parties are among the possible initial measures. The employer might also offer to refer the complaining employee to the Employee Assistance Program or another source of counseling. Particular care is required in responding to harassment claims that involve credible allegations of sexual assault or rape. Wrongdoing discovered through the investigation need not be so severe as to establish a legal finding of harassment to justify employer action. The hope is that corrective measures will stop offensive conduct before it becomes illegal harassment. The discipline and other remedies used should correspond to the severity of the harassment and be reasonably calculated to end it. It is critical that high performers not be treated more leniently than other employees. Terminations may sometimes be necessary and need to be conducted in the same careful manner as all other terminations and fully take account of any legal protections that might be available to the discharged employee. Transfers or reassignments can also be used as longer-term measures. Although a transfer is often the most expedient way to deal with harassment, victims should not bear the burden of being transferred to less desirable locations or positions. In general, the alleged harasser should be transferred or reassigned, and employers should provide for sufficient monitoring to ensure that harassment is not simply being transplanted to new surroundings. Harassment does not necessarily cease when complaints are made and employers take action. Employers should closely monitor the effectiveness of their efforts to remedy harassment. Measures taken at one point in time may be legally sufficient, but if they're not effective in ending harassment, stronger measures may be required. adequate remedial measures not only stop harassment, but to undo the damage it causes. In tangible employment cases, this might mean providing reinstatement, promotion, or some other employment opportunity lost due to harassment. In other cases, correction might mean restoration of leave that was used because of a harassment or an apology from the harasser.